Вітаємо, пані Ірина.
Welcome, Iryna.
Знову вітаємо
Again, welcome again.
вас. Сподіваюся, з учора ви не забули,
Let's hope that
хто така
you
конкурсна
have not
комісія
forgotten
і
forgotten
хто
since
в неї входить.
yesterday what the
Просто
composition
нагадаю
of
вам,
the
що
selection
доповідачами
commission
на
is.
вашому
Just let me
інтерв'ю
remind you that the
є
rapporteurs are
Євген
Evgen
Mezentsev
Mezentsev and Steven
І
Markman.
якщо я не помиляюся,
And if
то
I'm
ми
not mistaken,
вчора зупинилися
yesterday
на
we
вашій самопрезентації.
just where we interrupted during your self-presentation when you were presenting your motivations. So if colleagues don't mind, we could start with that point. Yes, that's what we will do, Ivan. We really were interrupted in the fifth minute. It was 5 minutes 30 and something seconds, and you were given the floor for self-presentation. So please, the floor is yours, Iryna. Thank you. Good afternoon, dear commissioners, dear audience. I would like to say that I'm the judge of the trial instance of the general jurisdiction. And since 2009, we have been considering all categories of cases. And we are the so-called working horses who have to hear the lion's share of court cases. The load in courts of general jurisdiction is very high in trial courts, and the cases are really very much diverse. And our court composition sometimes, in most cases, do not allow us to establish any court chambers to consider different case types. It's impossible to create judicial panels in the first instance courts. And this leads to delays in case hearings because we don't have permanent judicial panels, and even if we have vacation schedules, it's impossible to arrange the vacations in the way for a case to be heard by a judicial panel, because quite often there is a need for the judge to leave, to stop the vacation and to be present at the case hearing. That actually caused a lot of problems for our court. We really had to stop our vacation to hear specific cases that are related to prolonging some measures like detention or something like this. And at the moment, I cannot tell that this is good. I think that this is actually not quite good. It would be better to have it not just only for the period of the martial law. This is one of the articles of the criminal code that allows to settle those issues, but by the chairman of the judicial panel. What I'm driving at? I'm driving at the fact that the HQCJ will face a lot of issues in its activity that will be related to filling the vacancies that have unfortunately appeared in courts of general jurisdiction. Because it is in such small courts that we feel this staff shortage to the greatest extent possible. For example, the High Council of Justice has passed a decision recently that one of the judges of the neighboring court should retire, and there is only one judge in that court. So he was the investigator, the judge investigator, and then all the cases coming with such indictments to court should be transferred to the appellate court because, the one who retired. And normally, if we have a small court with 8 judges, and some of them are.
Отримуємо ці справи. Тому я вважаю, що саме суддя першої інстанції загальної юрисдикції повинен представляти
On vacation. So this means that we cannot consider and hear any cases.
такий суддя повинен сприяти тому, щоб
And I think that judges cannot work in a full-fledged way under such circumstances. Okay, it's clear. Thank you, Iryna.
Перейдемо до даних, які ви зауважили у своїй мотивації. Зокрема, ви зробили таке досить впевнене,
Let's go over to your motivation letter.
твердження про
You
те, що у
claim
вас за
there
час роботи
quite
суддею
confidently that over your
сформувалося
period
бачення,
of
яким
judicial
має бути
career,
чесний і
you
непідкупний
have got the
суддя.
impression what an impartial
Непогано.
judge should be
Не хотіли
like.
б поділитися ваше бачення, яким має бути чесний і непідкупний суддя? Прошу.
Please share this vision with us.
зрозумілим пересічним громадянам. По-перше,
First of all citizens should be clear about this judge, about his way of living, about his income and property, and
повинні бути зрозумілі для громадянського суспільства. Такі, які не бояться
and about all his decisions. He should
і такі, якого є нульова
advocate his point of view. He should be able to convey his message
ще таких
Unfortunately, there is very bad level of sound on the candidate's side.
Зрозуміло, пані Ірино. А що ви
Well,
вкладаєте
Iryna, it's
в
clear
поняття
in a way,
нульова
but
толерантність?
what do you mean by being clear for the citizens? And what do you mean, for example, by the notion of zero tolerance? Well, I think that it's a clear notion that you all know about. There should be no corrupt acts. There should be judicial
Ну,
discretion. Oh, okay.
Давайте ми скоротимо.
Let's shorten your answer in a way. Let's shorten your contemplations
Людина з нульовою
and narrow it down to the following statement. If a person has zero tolerance, and if a person, a judge to be more specific, sees that someone in his court, some judge in his court is committing a crime of that nature, a corrupt act,
відповідні
does
органи
he
про
inform
вчинення такого злочину?
the respective bodies about the crime or not? So zero tolerance, does it include this information provision to the bodies? Well, I think that it's not actually possible in practice to see. Well, of course, I don't mean that some other judge will just show up to the other judge saying that, okay, here is the money I've collected as a result of bribery. But there may be some data and reliable data showing that this person is trying to do something and pass a certain decision on the basis of bribe taking. So a person with zero tolerance, will he or she inform the respective bodies about that? Well, I think that there are the respective bodies to deal with that. Okay, please make a pause. Let's go back to judges. It's judicial zero tolerance. So does the zero tolerance of judges include going to the law enforcement bodies to say that as you think your colleague is committing a crime? This is not an exam. This is just your opinion that we are asking for. Well, since a crime can be proven only through an indictment and the sentence of the court, then I don't think that we can actually state that the crime has been committed. I'm not talking about the crime being committed. I'm just talking whether your understanding of zero tolerance of a judge to corruption includes the possibility that the judge would go to the law enforcement bodies to tell about the fact that a crime is committed. I think it's possible. All right. According to the data that we have got in our disposal, on the basis of your declarations, we can see that you possess
Особисте
and
приміщення, в
own
якому ви
just one
проживаєте. Це квартира
apartment
у
where you
місті
live
Первомайську,
in
39
Pervomaisk,
квадратних метрів, які ви
39
придбали
square
у
meters, and you
12
bought it in
році, за
2012
суму, яка відповідає ринковій.
for the
Правильно
amount
я
that is
розумію?
actually like the market value.
З 12 року у вас
Yes,
інших
yes.
об'єктів
No
нерухомості у
other
вашому
real
користуванні
estate
або
objects
володінні не було?
since that period of time obtained by you or owned by you? No.
Добре, тоді питання таке.
Then here
Згідно
is the
ваших
following
декларацій
question.
за
According to
15,
your
16,
declarations for
17 рік,
2015, 16,
ви
and
зауважили,
17,
що
you mentioned
ваше місце
that your
реєстрації
place of
не
registration
співпадає з
does
місцем
not coincide
фактичного
with the place of your actual
Причому
residence.
це перший аркуш
And
декларації.
this is the first sheet of the declaration, the first page of the declaration. And there is information there that the place of your registration and actual residence over these 3 years are in Pervomaisk.
І при цьому розділ, який
And the
вказує на
section
нерухомість,
with the information about real
зауважував, що у вас
estate
лише одне
says that you have
приміщення.
just
Саме
one
ця
apartment.
квартира на 39
This
метрів.
is the
Скажіть,
apartment I have
чому
mentioned,
в
39
декларації
square
з
meters.
15
So
по 17
why
рік
do these three
ви визначали
declarations
неспівпадіння зареєстрованого
include
місця і
data
місця
on
фактичного
non-correspondent
проживання?
between the
Тому що з
declared
18-го року вже все в
ownership
порядку, у
of
вас
yours
збігається
and
і зареєстроване місце,
actual
місце
place of
проживання.
residence? Because in 2019 and 18, everything is already coinciding. Because that was the apartment where I was just formally registered, starting with 2012, when then I bought this apartment and I went there to live. And this is the apartment of 39 square meters. It is a two-room apartment, and the previous one used to be a one-apartment room, and that was the apartment of my mother, located in some housing cooperative, of which my mother is the member. My mother got ownership of this apartment because she inherited it under the law. Well, I just thought that since my registration is only a formal thing, I'm not a member of this housing cooperative, and there are no belongings of mine in that apartment. And my mother was not the elderly lady as yet, so there was no need for me to be taking care of her. That's why there was such a discrepancy, because the actual between the actual place of residence and
Зрозуміло.
my
Пані
ownership.
Ірино,
And she
пані Ірино.
just let some
Пані
other person live in that apartment.
Так, будь ласка,
If I
пан
could
Іван
have
хоче
some
щось уточнення вам
clarification.
зробити.
Пані Ірино, це таке технічне питання. Ви можете в Zoom
There is a technical
обрати
issue. Could you
мікрофон
choose the
гарнітури,
microphone
а не
of the
комп'ютера?
headset and not the computer
Там-
in
там є
Zoom?
такий вибір,
Because
опція,
your
там,
sound is
обрати,
really bad. There is an
вашу
option there
гарнітуру,
that you
ну,
can
яку ви
choose your
Тому що фонить.
not computer
Або,
but the headsets, because otherwise we cannot hear you quite well enough, and it's difficult for the interpreters.
Вам зараз наш
to
технічний
work.
спеціаліст
Our
напише
technical expert will
повідомлення,
write you a
як це
message in
краще
Zoom how
зробити.
you can do
А
this.
Ми ці пару хвилин, да,
And we will
ми ці пару
just,
хвилин не будемо включати в загальну трансляцію. Тому
Make
що
a break for just several minutes, because it's really difficult for the interpreters to translate. They cannot decode what
ви
you
просто,
say.
У вас от гарнітура є, да, оці ваші навушники і мікрофон. І вам треба його увімкнути, да, щоб ви через нього
So you have the
говорили, а ви
microphone
говорите через,
and of the computer,
спікер
and you have the
ноутбуку чи
headsets.
комп'ютера.
So you should choose for headsets.
Спробуй, якщо це можливо.
Okay,
давайте
I'll try
спробуємо.
to. If it's possible, please try to.
Ну, добре, технічна перерва тоді. Okay. I hope we solve the problem.
Так, продовжуємо. Скажіть що-небудь, будь ласка.
Say something just for us to check whether the sound is fine. So good afternoon once again. So now the sound seems to be much better. Thank you. So let's
Дякую, пане
continue.
Іване.
Thank you.
Ну, давайте з новими силами,
So
пані Ірино, продовжимо наше
let's
спілкування.
take a new effort and continue our communication. So Irina, if I've got you right, you owned an apartment in Pervomaisk, which you bought in 2012, and you were also registered at some other address in the apartment which actually belonged to your mother. Did I get you right? Yes.
І квартиру вашої матері,
And
які ви були
the
зареєстровані,
apartment
ви не
in,
відображали у
of
декларації,
your mother was
як
not
інше
reflected
право
in the
проживання,
declaration
так?
as another ownership of yours
Все,
and the right
дякую, відповідь
to
отримана.
reside. Yes, you're
Інше
right.
питання, яке я
Okay,
хотів вам
here is
поставити
another question I would like to
стосовно...
ask you.
Одну хвилиночку.
Just a moment.
Хвилиночку. Такого собі аспекта, який ви також
This is the question
зауважили у
related to
своїй
one of the aspects which you also
мотиваційній
mentioned in your
промові. Ви
introductory
завказали,
speech.
що серед
You
інших,
mentioned that among
чеснот
other
або
virtues
етичних
or
правил,
ethical
які існують
rules
на теперішній час,
that
вам при
we
роботі
have currently
в
got,
ДКС буде найважче
the most difficult
дотримуватися
thing, it's actually not in the
співчуття.
introductory speech, but in the motivation letter, you mentioned that it's most difficult for you to keep with the principle of empathy, or what do you mean by this?
Почуття емпатії мені притаманне, але
No, I do have this sense of empathy, but
ми будемо оцінювати
it's all about a different thing. We're going to assess different groups of people, including people who are older, and they will be concerned, they will be anxious during the selection process. They will have high blood pressure.
І ви безжально будете їх таки дресирувати.
якраз я хочу сказати, що мені буде
So it will be difficult for me to keep from having some empathy for them, because I will have to assess their objective qualities, and I cannot pay attention to some human things, to the fact that they feel bad during the interview, that they feel bad, they have high blood pressure. I will not be able to do this. So I mean that I will probably tend to shift the focus of my attention. I don't actually mind. I participated in the qualification assessment, and I saw some ambulances staying close to the premises. Well, I hope that we won't have situations like that when we have a queue of ambulances close to the premises of the HQCJ. Yes, but they were like on duty there. In particular, when practical assignments were performed, because that was the qualification assessment of judges, so it was done just in case judges feel
Я
bad.
вас зрозумів. Скажіть таке, ще теж питання пов'язане з вашою декларацією.
Here is another question related to your declaration, but not declaration for 2015, 2016, and 2017, but for 2019 up to 2020, 2021. They are all united with one feature which CSOs have actually paid attention to, which claim that in spite of the fact that you are getting your salary, you did not declare availability of the bank account,
не грошів на банківських рахунках.
not money in the bank accounts, but the numbers of bank accounts, which should actually be indicated at least in the latest declarations. And that was mentioned because there is the requirement like this set by the law. You have to indicate since recently the numbers of your bank accounts. It's a problem. It's also a problem for me to collect all the bank certificates, what kind of numbers of my bank accounts are, because it's like 18 symbols each. But what about the problem for these years? Why didn't you indicate the number of bank account? Do you get your salary in cash? No, of course I get my salary not in cash. I get it the way all judges get it, through the offices of the territorial offices of the state tax inspection, and of course this is done to a bank card account.
вважаю це своєю
Well, it's a mistake of mine.
наміру щось приховати.
But of course, I didn't in intention to hide
Номер
anything.
рахунку приховали.
Well, but you have hidden the information about the bank account number. Well, you know, for 2021, I have not yet submitted the declaration because it was in March 2022 that the explanations were provided by the NACP that
Наразі ви
during the
вирішили
martial law
кандидувати,
you will have
змушені її подати.
to give the declaration within 3 months. But after 3 months, when the martial law is over. But you were the candidate, so you had to
Зрозуміло.
submit the declaration. But I just thought that I need to declare the bank accounts where I have some money. Thanks God, I participate in this selection. This has enabled me to understand at least what is demanded from me, what the requirement is in this respect. And of course, now I will definitely remove this
Пані
mistake.
Ірино, дякую вам, дякую
Thank
за
you,
ваші
Irina.
відверті
Thank you for your
відповіді.
clear
Передаю
answers, and let me give the
право
floor
поставити вам питання
to
моєму
my
колезі,
colleague,
шановному судді
Judge
Стівену.
Stephen. You're welcome.
Hello, Judge Shykeria. Thank you very much for your participation. As I read the motivation, I look at the first question, and to me it seems as if you responded to a different question than the one that was asked. The question that was asked in number one was, what is your motivation for participating in this competition? And then I read your answer, and it seems like it's focused almost entirely upon your qualifications, your autobiography. We of course know of your autobiography, and we know that it's strong, but I guess I'd like to ask you again the question that was set forth in number one, and I'll read it. Please provide your motivation for participating in the competitive selection for the position of a member of the HQCJ. What is your motivation for participating in this? What is it that inspires you to get involved in this thing?
As I've already indicated it today in my introductory speech, I would like to have a judge in the HQCJ, a judge from a small court, an ordinary judge, hearing all case types, a judge of the general instance trial court. That is really necessary to have such a person in the HQCJ, for the HQCJ to understand the needs of the courts and judges of this instance, of trial courts. And this is the first thing. And the second thing is that incompleted qualification assessment of incumbent judges and unfilled judicial vacancies in courts are a real problem, along with availability of the judges who are appointed for a 5-year term and who are not administering justice in spite of the fact that they have good work record of 5 years, but they are experienced judges. I mean, they are professionals. They are not administering justice. So for me, this is a thing that causes my indignation, because professionally competent people are forced to just wait until the commission is established for them to be recommended to those positions. So I can work quite a lot and persistently, and I can work late hours. And that's what I actually normally do. And I sometimes go to my workplace on weekends, at weekends. And that the reason for that was that we had some procedural timelines, and we could not postpone anything. So I think that the load of work the HQCJ will have to do needs to be shifted onto the people who are not afraid of doing this work.
Well, again, you're talking about your qualifications. You're talking about your qualifications, not your motivation. I think you've given some answer on your motivation, but as I understand it, you're repeating why you feel that you're qualified for the commission and not what it is you hope to do as a member of the commission, what legacy you hope to leave, what changes you hope to accomplish. Do you want to add anything further in that regard that you think maybe you haven't already addressed?
Well, what kind of changes could this be? For example, I would expand the mandate of the members of the PRC for them not just to be able to provide a negative opinion, but also to provide a positive opinion. I think it is civil society that knows both the virtues of judges. At least they can assess these virtues from a side. And it would be good if they could be providing not just negative opinions, but also positive opinions. This is one of the changes I would like to introduce.
Хотілося б також, щоб дещо було спрощено
Also, it would be good to
проходження
have a procedure for judicial candidates. I mean, their training to be probably shortened. I mean, that probably the period of time in between some procedures or stages of the procedure should be shortened. But as far as all the other things are concerned, well, I don't know, but when you start doing something, it becomes more clear for you as to what can be done and what should be done. But now we are just talking about the plans and the intentions. But plans are good, but we should somehow ground our judgment on the reality, on what happens in reality. Probably we will have to reconsider the plans even if we make them.
Well, aren't you going to be in charge of defining that reality? As one of 16 members on the commission, you will be helping to define the priorities of the commission. You act as if the reality is not within your control at all. Don't you have some influence over the reality of what the commission will be doing?
Well, sure, you're right, but I cannot tell you exactly what we will have to do. If I worked in this position for about a year, at least, I could probably be able to speak in detail about this, but otherwise it's going to be a new position for me, not the one I have been holding over the recent several years, 20 years or so. So there is some new type of activity for me, so I can develop some plans, but actually I cannot clearly tell you what I would be doing there. Mm-hmm. It's not that I can, but it would not be absolutely realistic. I see myself as a person who will join in the judicial reform in this process of filling courts with high-quality judges. And I will do my best to really accomplish this.
And Judge, you say that one of your strengths is the fact that you come from a smaller court. Can you just give me an illustration of what insights or what recommendations you might have that come from the fact that you are from a smaller court than someone might have coming from a different type of judicial body? What different perspective would you bring to the commission?
So, different people work in different courts of different jurisdictions, but people know the needs of the courts where they work, including staff needs. They know how many vacancies are not filled in their courts, for example. And I think that we should have a representative in the HQCJ from a small court, because half of the composition of the HQCJ are supposed to be judges, and these should be judges of all jurisdictions and all court instances, administrative, commercial, general jurisdiction courts. So then there will be some consensus because the needs of everyone will be known, and then the decisions will be right.
Can I ask you one final question, Judge? We have a competition with what I believe are many good people, and good, including yourself. It's not a competition between qualified and unqualified people, but a competition among generally highly qualified people. What is the one thing that Judge Iryna Shykeria would be able to contribute to the commission beyond that of the other very capable applicants for a position? What is your foremost strength that you would emphasize, the foremost area in which you think you could make a long-term contribution to the work of this commission?
Я хочу проводити, не боюсь змін.
Well, I'm not afraid of changes. I would say that this is my strength.
Які відбуваються. І крім того,
I'm not afraid of changes
хочу долучитися
occurring in reality, and I would just like to join in the completion of the judicial reform.
Okay, thank you very much, Judge. Let me turn over the questioning to Judge Zarzeczny, please.
Yes, good afternoon, Judge Shykeria. I'm interested in your comment, and there's information that has been provided to us that you were a candidate for the High Anti-Corruption Court. And I wonder, firstly, were you referred for an interview in respect to that competition?
так,
Yes, I actually passed this competition, all the stages. I mean, I was not recommended for the position, but I was recommended for the interview, and I was acknowledged to be the one who can, well, I'm lost for words, who is capable of being a judge of the High Anti-Corruption Court, and I passed qualification assessment.
I see, all right. So you were not interviewed by the Public Council of International Experts?
з громадської ради
No, I didn't have the interview. I had the interview with the members of the commission.
Right. And that's a good thing, by the way, because the only interviews that were with candidates that had some questions with respect to their integrity. So that's a good thing that you were not referred for the interview. But that experience, together with your qualification assessment, which was also conducted by the High Qualification Commission for Judges, would have involved both of those, all of the processes that were in place to scrutinize judges by the High Qualification Commission of Judges. What was your view of the good parts of that process, and are there any parts of the process, since you've undergone it twice, any parts of the process that you would change if you were a member of the High Qualification Commission?
взагалі у мене позитивні були враження.
Well, generally, my impression was positive as a result of that selection. In particular, the one for the judge of the High Anti-Corruption Court. And when we arrived in the premises where this was all taking place and where we were writing a written paper, writing a practical assignment, and we had it simultaneously with the candidates for the positions of judges of the Supreme Court, that was large premises everything was organized well. But when there are many people, it's very difficult to organize everything. And it seems to me that that is another advantage of this competition, that it was rather well organized. But of course, there were many people, and there was a lack of technology, and it was difficult for me to write it manually. I used to write protocols of court hearings manually. One of them was the protocol of 280 pages. That was a very difficult case. But at the period of that competition, of that selection, it was kind of awkward for me to be writing any decision, to be writing anything manually. So, of course, what we should change probably should be automation and the number of technology items we have in our premises. But during the qualification assessment, we already had computers, and that was easier. But in general, my impression was positive, and I liked participating in this selection. So I don't have any obviously negative things to tell about.
Yes, and did you, prior to your appointment as a judge, I know that you worked as an assistant judge, but was it required that you go through the National School of Judges training program before you were appointed a judge?
Not exactly. When I was appointed a judge, there was no requirement to have a training in the national school. It was enough to have the work experience of being an assistant judge for 3 years. So nobody actually referred me to the National School of Judges, so I didn't have this training back then. And I think that, well, it is in a way good that I had a chance to study at my workplace. And while working as an assistant judge, I also worked as an assistant chief judge, and then I became a judge, and that's where I've got my practical skills, which were at a rather good level, at least as far as writing decisions is concerned, and the form of those decisions is concerned.
Have you kept up with any training programs while you have been a judge?
Yes, sure, and there is the requirement of the law. And judges appointed for a 5-year term, when they are appointed for the first time, and that was the way I was appointed, they have to undertake some training, regular training, once a year. While judges who are appointed for an indefinite period of time have to have such a training once in 3 years. So I have those regular trainings, and besides that, I do participate in different seminars, and different workshops for one day, for example. So these are the ones which are now conducted in Zoom, so there is no problem about that.
I see. Have you ever attended the premises of the National School of Judges? I know that they have premises in a number of the cities, not your city, but have you ever attended the National School of Judges to see how they work and what the curriculum for studies at the National School includes?
Yes, I've been to the premises of the National School of Judges in Odessa. Oh, well, it's quite nice there. But that was rather long ago. So but I don't remember the specific occasions why I went there. But anyway, I attended the premises. We had some workshop there, but I cannot exactly recall what it was.
Have you reviewed in preparation for your application, or since you've applied for a membership in the High Qualification Commission for Judges, have you reviewed the curriculum of the National School of Judges to better understand the training that judge candidates go through?
Нам постійно направляється школою суддям на
Well, the National School of Judges keep sending different curricula and proposals to our email addresses. And, you know, if our schedule allows us to participate in a certain training, we may do this. Because, you know, during the training, the judge cannot be hearing cases. And if there are cases that need to be heard very quickly, urgently, and when you need to settle some important matters, and these cases have been appointed for consideration for this period, so the judge cannot participate in any training. But otherwise, we may accept these offers given by the National School of Judges and send to our emails.
обов'язкове навчання і періодичне навчання
But
студенту
normally, we have some one-day trainings. It's still possible to find some time to have one-day trainings. In case you come to know about these trainings in advance, you can like readjust your work schedule because you know in advance that you will have to undergo this training and not to hear cases on that day.
I will ask my last question, and it is a subject that you have already been asked a question about, and that is your comment that when performing your duties as a HQCJ member, it will be most difficult for you to follow the ethical value of compassion with regard to participants of the competition. So in other words, if I understand that correctly, and it may be an issue of interpretation, you're saying that you are a compassionate person and you will have to put compassion aside when you are doing the work of the HQCJ and assessing candidates. Is that what you're saying there?
Yes, you've got it right. I myself am quite anxious. I can worry about a lot of things. So I understand how difficult it may sometimes be for a person to be taking a test or an exam, in particular if this is a person who is not that young, of middle age and an elderly person. So I understand a senior person, I mean, in particular if it is a woman.
I see. Do you find yourself compassionate when people appear before you in the courtroom? Do you feel compassion for them?
Я розглядаю спори, чи
Well, I hear some disputes and accusations.
я і сам повинна, в принципі, абстрагувати.
And in the courtroom, I should also be standing aside from compassion. And, you know, sometimes the parties to the case may show some behavior that would actually evoke compassion on the part of the judge.
Як то кажуть, вона бідна нещасна.
For the judge to feel that this person is needs so much, is so poor, and you should feel pity for him. But I think that you always have a chance to ask questions and to clarify what the situation really is like. Sometimes, probably, we can take this into account, but that will not be the basic thing. That will not be the ground for the decision. The main thing for the decision to be made is the evidence provided by the parties.
All right, thank you. Thank you for your answers. I'll invite you to answer the questions of my colleague, Mr. Broekhuizen.
Good afternoon, Irina. I hope you don't mind that I say Irina. I noted down that you said you told about the fact that your court, the court where you're working, is very small, and there are only 8 judges presently working, and that you're completely short of staff, and that you work day and night in order to cope with the work. And of course, the question then arises: what happens if you are elected in the HQCJ? That it doesn't get better for your colleagues then.
Я сподіваюся, що у нас на даний час
Well, at the moment, there are people that can replace me. And when the new HQCJ starts its work, regardless of whether I'm being selected or not, we have this judge who, should she complete the qualification assessment, she will be able to replace me. But I'm not saying that I will be involved in helping her to pass that qualification assessment. Of course, I will announce self-recusal.
Okay, and it does also mean, because I looked up where the court is, it's quite far away from Kiev, that you have to move to Kiev if you would be elected.
Yes, I will have to move.
Okay. Another thing that I wanted to discuss with you is the discussion you had with Mr. Metsensev about zero tolerance for corruption. And at a certain moment you said, and maybe I didn't write it down correctly, but something like, yes, we cannot say that something is corruption unless it has been determined by the criminal court. You recall this, that you said this?
мова йшла про злочин.
We were talking about a crime. The fact that a crime has been committed, and this fact must be proven by a verdict. In this situation, we can talk only about suspicion or maybe even an individual's personal view of a situation they are witness of. We cannot say that a crime is taking place unless we have the evidence and we have some relevant authorities who are supposed to prove that. But yes, we can have some suspicion that a crime is happening.
If I would say to you that, let's say, as a lawyer, in principle, I do not agree with you that this is the correct view, how this should be viewed. Let me give you the example that someone is killed. Yes, and you see the killing take place, and you see someone walking away with the knife. Yes, a criminal case. Then, of course, the crime happened when the person was killed, and the facts are clear. And then it is not necessary that, in order for you to decide that a crime happened, that there is confirmation by the court afterwards. And the reason I give this example is that when you get to know about corruption, you have to make up, in my view, your own idea whether or not this is a criminal offense. And if it is, then you have, I believe, as a judge, to report the corruption to the authorities. Or do I say something that you do not agree with?
Well, of course, if it's a perfect situation, then I can agree with you, but we are talking about corruption still. It's not the crime where we can see somebody walking away with a knife in their hand. It's not the type of crime that is obvious. These crimes must be proven.
As always, huh?
If it's so obvious, then it means that a person has been an accomplice in that crime, if the crime is obvious to them.
But wouldn't you say that there is a difference between the question whether someone is prosecuted and condemned to imprisonment, and the question whether there are enough, let's say, proof that that there has been something going wrong in corruption, and that makes that this person cannot continue to work as a judge? Do you have to wait first until a judgment of a criminal court exists before to take someone out of the system for corruption? Is that what you say?
Well, if we are talking about removing judges or maybe suspending judges from their positions, it's the mandate of HCJ under the petition of the Prosecutor General. So that's a decision that is made by a competent authority. The Congress of Judges or one specific judge cannot decide in this situation.
No, of course. But let's say that you're a member of the HQCJ and you receive information which you believe to be trustworthy, that your colleague has received a bribe to accept the application of a certain judge. What would you do?
Everything will depend on how obvious the situation is to me. Depends on the facts that will be available to me, because sometimes there may be ungrounded accusations, libel, let's say. I don't want to be somebody who is making such accusations. It will all depend on specific circumstances.
Of course,
whether I will be able to prove those facts, whether the crime really did take place, whether something happened that would require for me to report an alleged crime, or at least a situation that calls some suspicion.
Well, the facts that I put in front of you is that you have received information which you find to be completely reliable. What will you do? Because what the answer you give is a lawyer's answer. There's always the proof issue, of course there is. But the question is, let's say that the information you receive, you consider it to be reliable. For instance, they come from Mr. Zazeczny, who you're sure that you can trust him.
I will first have to talk to Mr. Zazeczny and find out what it was exactly that he saw or heard. Maybe it was his personal perception of this situation. We need to see whether we have some actual facts that we can take into consideration.
You speak to Mr. Zazeczny and then you speak to Mr. Markman and he confirms the story. What will you do?
Well, you're describing something that the prosecutor's office is supposed to do. When they are having eyewitnesses, when they're questioning them, it's not something that a member of HQCJ should be doing, like having their own investigation with regards to a colleague. But if it's really obvious, if it's something that cannot be ignored, then of course I will have to report.
Okay.
But only in a situation when it's really obvious and I can reason all the facts while reporting to those competent authorities. I can provide reasoning.
Yeah,
I don't want to be accused of being jealous of that person.
No, of course not. And the only last remark I make before I pass the floor to my dear friend Sergey Verlanov is that, of course, fighting corruption, zero tolerance, is only it only works even when some people report, because without reporting, it will be, you can say zero tolerance and zero corruption, but it will never be there. Sorry, my last remarks.
Дякую, пан Роберт. Доброго дня, пане Ірино.
Good afternoon, Irina.
Я хотів би вас з'ясувати, чи ознайомлювалися ви до
I have this question for you. So, prior to your interview, have you studied the materials of your dossier, the information from civil society organizations that we have? Yes. So, I'd like to discuss one of the questions asked by civil society organizations. With regards to you making a decision in an administrative case in November of 2020, with regards to people's deputy, with regards to a deputy of Lisogora Village Council, with regards to an administrative offense. So, in your ruling, you closed the proceedings initiated against the person because of a cancellation of an act installing administrative responsibility. And thus, civil society organizations have this question. And in your reasoning for closing the proceedings, you referred to a ruling of the Constitutional Court of Ukraine with regards to holding people accountable for some corruption offenses. And at the same time, if we are looking at the Code of Ukraine on the administrative offenses, we can see that there were no actually grounds for you to close those proceedings. Can you please explain why? Yes, so the question is about reasoning, my motivation behind closing the proceeding, because there was also a complaint about me missing the procedural terms. Yes, that's also the other question. So let me provide comments on the two aspects. Well, actually, I did not miss any procedural terms. That's what they think. I consider that case within the procedural terms. The civil society organizations believed that I intentionally postponed the hearing on the date when the Constitutional Court has already made their decision. So they say that I foresaw the decision of the Constitutional Court, something like that. So with regards to this case, I can provide you the following explanation. So let's not go into details. So did you really have grounds to close the proceedings? Because civil society organizations claim that the decision of the Constitutional Court of Ukraine actually doesn't say that you had those grounds. So let me explain my motivation. Since Article 172 of the Code of Ukraine on Administrative Offenses regulates the violations of the requirements of financial control, and actually it's a norm that refers us to the law of Ukraine on fighting corruption, and the decision of the Constitutional Court of Ukraine, yes, it did cause constitutional crisis. It was about holding people accountable for mistakes in their declarations. And here I agree with Mr. Sidorovich, something that he mentioned in his article published for the Ukrainska Pravda newspaper with regards to judicial activism. So I just got carried away. Forgive me for that. So my reasoning was as follows. Since Article 65 foresees responsibility for violation of this law, and we have reference to Article 175 of the Code of on Administrative Offenses, since that Article 65 was cancelled altogether, and It's mentioned in the law that there is responsibility for all people who have violated this law, and the terms and procedures for declaration were mentioned in the law.
Я вважала, що що це створило
I believe that this created a situation of legal uncertainty.
і відповідно до принципів
And consequently, according to the principles of the rule of law and not just the positive law approach, when we have this norm that foresees responsibility for a person, so regardless
накладення стягнення фактично
of the norm which says that there should be some kind of
залежності від того,
punishment, depending on whether the person violated the norms of the law, and for the violation of the norms of the law, the responsibility has been cancelled. So this situation of legal uncertainty did not give me grounds to punish the person,
адміністративне стягнення
because administrative punishment and the European Court for Human Rights is saying that it's punishment in its essence. That's why I made that decision.
Ну, враховуючи те, що ми перевірили по реєстру
Thank you, Iryna. So we checked
набрала законної сили, то,
that
звісно,
the
ми,
ruling has not been
не можемо
appealed,
ставити
that
її
ruling
під
made
сумнів.
by you.
Зрозуміло.
We cannot
Але
be
мотиви
doubting.
ваші зрозумілі
And
щодо
now
цієї
thank you
ухвалення
for
даної
explaining your reasoning for
постанови. І
making that
наступне
ruling in
запитання
the
у вас,
case. And
знову ж
my
таки,
next question
з приводу запитань, які викладені у довідці
has
громадських
to do
організацій,
with
це по
the
справі,
information presented by civil society
від,
organizations again, and that
30-го,
relates to the
номер
case
1421, дроб 3679, дроб 12, це про виправлення описки,
correcting
значить,
some
30
typo
липня 2012 року
in July of
під вашим головуванням
2012
була постановлена ухвала про
when
виправлення
you were the
описки у
presiding
рішенні
judge
від
and
10
you ruled
10
to
травня
correct
2012 року.
a typo in a
Це,
decision
справі за позовом про визнання
in
права власності
case
на житловий будинок. Не буду
on
вказувати
acknowledging the
сторони, але
right of
на
property
житловий
to
будинок. Вам
residential
так, звісно,
building.
да?
So you must be aware
Да,
of
ви
that
також,
case as well.
І ви
Yes,
за
that's something
заявою
that I
позивача
wrote
виправили
about.
описку
So
у рішення
you
саме.
decided to
Ви визнали
correct
право
that
власності на
typo
житловий
in
будинок, а
that
потім
decision.
за
You
заявою
acknowledged
позивача
the
виправили,
right of property to that
про визнати
residential
право
building, and
власності
then
на
you made a correction
11:30 цього домоволодіння. Ну, і,
saying
звісно,
that
запитання,
the right of property should be
громадської
acknowledged
організації,
for
чи фактично, чи ви змінили
11:30s
рішення, чи
of
ви
that
провели описку даного?
residential
Ви як
building. So the
оцінюєте
question is, have you
безпосередньо
changed your
свої дії?
decision, or was it
Процесуальні
really
дії.
a typo?
що я захистила в невизнані державою права.
So I protected the rights of the petitioner, actually, the rights that were not acknowledged by the state. The petitioner has been the owner of that house since 1999.
Ні, це ви вже по
And
суті
they
говорите.
went to
Тут іде
court in
саме мова про
2012. You are
процесуальні,
now speaking on the merits of the case,
даному
but let's talk
випадку
about the
рішенням було
procedural
визнано право власності
aspects.
на все домоволодіння
So
за
you
особою,
acknowledge
правильно?
the right of ownership to the entire house initially.
Так, але в подальшому,
Yes,
за
but
заявою
then
однієї з сторін, ви виправили
there's been a correction
про визнання права
introduced.
власності на частину цього
An
домоволодіння.
amendment
Так ви
was
змінили
made
рішення,
to the
фактично,
decision.
чи
So
ні?
have you
Резолютивну
changed
частину
your mind? So
змінили, чи ні?
have
Як
you
ви вважаєте?
changed the decision?
Скажіть, будь ласка, як суддя.
As a judge, can you please explain this?
Особа не була, скажімо так, у особи не склалося,
That individual
покладає свої помилки на неї.
did not have the, I wanted for the individual not to have that impression that the court was trying to shoulder some responsibility onto their shoulders.
І поважних причин для того,
There were no actually serious grounds
такий строк на подачу
to restore the terms for appealing the decision.
дана особа 48
And that individual was born in 1948.
була фактично, їй було дуже важко.
It was very difficult for the person, and that was explained by the lawyer who filed the lawsuit. It was very difficult for that person to even pay the fees. And pay the lawyer for drafting the lawsuit.
В такому випадку вважала, що з мого боку, як
So I believed that as a judge, in that case, it would be too formal
Я зрозумів.
відправити, подавати апеляційну скаргу,
to send that person to the appellate court knowing that they will not be able to appeal. So you believed that it was some kind of demonstration of extreme formalism. Thank you. Now that's clear. And my next question.
Від себе особисте запитання вже буде.
This is a question coming from me, not from civil society organizations. In your motivational letter, you are claiming that in order to enhance the level of trust in the judiciary, we need, among other things, to have an independent judiciary.
Поясніть, будь ласка, чи відомі вам
Could you please
приклади
explain
порушення
or
принципу
tell us
незалежності
whether you know of
безпосередньо
any
у вашому
cases of violation of this principle of independence within the judiciary? Perhaps within your own court?
Як таке
No.
невідомо.
I don't have any examples like that. And why did you mention that in your motivation letter, that in the future Ukrainian judiciary must become independent?
Що вона залежна
What
зараз від
made you draw this conclusion? Is it dependent at the moment?
Так. Ну, так,
Others
наведіть
are
приклад.
trying
Наведіть
to
приклад тоді,
exert some
якщо
pressure and
намагаються впливати.
influence the judiciary. In what way?
ну, хоча б даже заявами про те, що
Well, by making these statements that all judges are bad, that they don't have integrity, that we should boil them alive. Some people are just saying that. Some activists are making such statements.
Зрозуміло, пане Ірино. Добре, дякую.
Yes, thank you. That's clear,
В зв'язку
Ірина.
з тим, що у нас вже залишилось мало часу.
Because we don't
я
have that
передаю
much
слово
time
голові
left,
комісії.
I will now pass the floor to our chair, Mr. Mishchenko. Thank you.
Пані Ірина, уявімо собі, що вас
Irina,
призначили
let's
членом
imagine that you've been
ОБКС.
appointed as an HQCJ member.
Чи є щось, що змусить
Is
вас
there
написати
anything that
заяву
will
про відставку?
make you resign? Yes?
Що саме?
Yes? The state of my health, the only thing. When I will not be able to perform my duties because of some health condition. Yes.
Уявна ситуація.
This is an imaginary situation that I'm going to present to you. The HQCJ has completed some large-scale procedure, let's say a selection of a big number of judges. Many procedures have been completed, and the only thing that's left is to have this joint session of the commission, to have some voting, to sign some documents, and that's
Це
it.
результат там багатомісячної
And
роботи
that's the
комісії.
result of many months of work of the commission.
Якимось чином у вас опиняються
But
документи, які беззаперечно
Somehow
свідчать про
you
те,
come across
що голова
documents
ОККС
that
причетний
prove
до
that
корупційних дій.
the chairperson of HQCJ is involved in
І
corruption.
якщо ви опублікуєте ці
And
документи,
if you publish these documents, if you report to law enforcement bodies,
вся ця багатомісячна робота
the result of many months of your
як
work
мінімум ще на декілька місяців буде
will
відкладена.
be
Буде великий скандал.
postponed at least for
Ніякого
several
засідання
months.
комісії
There
не
will
буде.
be a huge scandal, there will be no session of the commission, and the country will not get that result.
І ви можете ці документи
And you
оприлюднити чи
can
передати правоохоронним органам,
Publish
скажімо,
these
після
documents
такого
or
засідання комісії.
transfer them to law enforcement after the session of
Незважаючи на
HQCJ.
те, що голова, якби, що є документи, які свідчать про те,
Because
що
even though you
голова,
have these
якби,
documents that
замішаний в якихось
confirm
корупційних
some
діях,
kind of
на
involvement
результати
of the
цього
chair
проекту
in
він вже ніяк-
corruption,
він чи вона вже ніяк не вплине. Тобто
this
там
person
лише
can no
формальності
longer
залишились.
influence the results of the
Що ви оберете?
process. It's just the
оберете
formalities
прямо
that are
зараз?
left. So what will you
Чи ви
choose?
все ж таки
To
дочекаєтесь
publish the
цього
documents right
формального
away
офіційного
or to wait
засідання і завершення
for the
цих
formal
процедур і
session
оприлюднити ці
for the
документи?
completion of all the official procedures and then publish that document?
під час здійснення цих процедур
If in the course of the procedures,
Ні, ці документи
no,
до
no, no,
процедури
the
відношення
documents have
не мають
nothing to do with your
Скажімо,
procedures.
уявімо собі, що
Let's
всі корупційні
just
питання
imagine
пов'язані, не знаю,
that
з тендерними
the
процедурами.
corruption
Ніяк не
had to do
пов'язано
with
з,
some auctions or
тими процедурами,
tenders,
які,
and it had nothing to do
пройшли.
with the
Питання в тому,
selection
ви це
conducted
зробите
by
зараз,
HQCJ. So
чи ви це
the
зробите
question
через
is, are you
декілька
going to
днів?
publish the
Після того,
documents
як комісія,
immediately
якби
after
завершить цей
having
юридичний
them
процес?
in your hands, or after that meeting of HQCJ, after the formalities are over? So I will maybe put forward a motion about removing that chair, about not having any trust in that chair, and I will put that for vote of HQCJ, and then the other members will have to decide.
Ви проводите кваліфікаційне оцінювання.
Thank you. So you are conducting a qualification assessment of a
У вас є
judge,
близька подруга,
and you have a close friend of yours
яка за день до цього кваліфікаційного оцінювання,
who
до
a day
вашої
prior
співбесіди
to
вам
the
телефонує
qualification
і каже,
assessment
що вона
gives you a
100%
call
знає,
and tells you that
що,
she is
цей суддя корупціонер. Вона
convinced
100%
that
це
the
знає.
judge you're
Це ваша
supposed to
подруга дуже
assess
багато років.
is a person involved in corruption. So this is your close friend.
Я якби
She gives you a
прямо
phone
зараз
call,
довести не можу, але
and
це
she tells you, I
100%.
cannot give you all the evidence over the phone, but I'm 100% sure he's corrupt. So what are you going to do?
Я їй скажу, коли доведеш, тоді
I will tell her, when you prove this to me, then you can give me another call. But she tells you, well, you have to believe me. You've known me your entire life. But we are talking over the phone. I need to see you somewhere. We need to have a meeting. I do have the proof, but I cannot provide it over the phone. But the interview is tomorrow. So what do you do?
скажімо так, голослівним твердженням по телефону.
Well, if there are statements like that made over the phone, I would not believe my friend. If she wanted to tell me about such facts,
Знаючи мене,
if she knew who I was, I'm not the person who just trusts words, she would provided some evidence. If she hadn't done that, it appears that she's trying to mislead me, and maybe
взагалі, чи вона не помста,
she has her own agenda. Maybe that's kind of revenge that she has against that person. If the candidate, maybe he's a man who turned her down sometime in the past, and she never told me about that.
знаючи мене,
If she knew me,
такими голослівними твердженнями, як
she would not call me, informing of such facts. Because my friends would not
І це ніяк не
do
вплине на
that. I
процедуру
don't believe
співбесіди, я
people who
казав.
just say these words.
ну, можливо,
Will it going to influence the result of the interview with that candidate? So maybe during the interview, I would ask the candidate whether he knows my friend. Maybe that would be the closed portion of the interview.
буде йти, якщо в мене будуть підозри,
If I have suspicions that there is a kind of a personal relationship there, then we can close this part of the interview and ask him, inquire what kind of relationship they have. And then it will depend on the answers that the candidate provides to the commission. If he starts being sneaky, then maybe I will have some suspicions and I will have to check. I will have to acquire some additional evidence. Thank you. Thank you. Your position is clear. Do we have any additional
Пані
questions?
Ірино, наша співбесіда,
No. Irina,
наближається до свого
your
завершення.
interview is about to come to an end.
Комісія надає вам можливість підвести підсумки.
The Commission is giving you an opportunity to sum it up. The platform is yours. Thank you. I would like to express my gratitude to the Commission for the opportunity to participate in this selection, for the opportunity to talk to you, to be a candidate,
такий шанс, який мені
for this chance that I've been given to feel myself
чувся до вершини, скажімо так,
as a person who is approaching this high position, this peak in one's profession. So thank you for giving me this opportunity. I would like to say that regardless of the result, whether I'm elected or not, whether I become one of the 32, it is obviously a very positive experience for me. Undoubtedly, this is an opportunity to realize what some of the mistakes made by me are. And should I be selected by you, I think that the commissioners can be sure that they will never feel ashamed of me. Thank you, Irina. So this is the end of your interview. Thank you for participation. All the best to you. Take care and goodbye. Thank you. Goodbye.